Boa tarde a todos e todas. Hello, everyone. My name is Flávia da Costa Viana. I'm a judge in Curitiba, Brazil, and the Director of International Affairs of AMAPAR, which is the Association of Judges of my state, Paraná. I'm very pleased to host this event today and to welcome you all here. So I'd like to begin by thanking our guests, Professor Matthew Stephenson, Professor Eduardo Jordão, and Professor Juliana Palma for having accepted our invitation. I've been saying that if something good came out from this pandemic situation, it is the fact that these online events make it easier to gather people from different places. In the past few months, we've been organizing webinars at our school with jurists, judges, lawyers, members of our National Council of Justice, professors, specialists, you name it, from all over Brazil and from other countries as well. And by doing that, I believe we end up reaching out to broader and more diverse audiences. Well, first of all, I would like to make sure our audience knows that today we are having a different format, and this event will be held entirely in English, meaning a live de hoje será inteiramente em inglês. And what is important to point out to our guests is that this session is not supposed to be formal, and by that I mean we can address each other on a first name basis. So with great honor, I welcome Matthew, Eduardo, and Juliana, who will have a conversation about a topic of interest of many of us, which is the judicial control over public administration, the United States and Brazil, and in comparative perspective. So now, cutting to the chase, I will read the bios of our very distinguished guests. Matthew Caleb Stephenson is professor of law at Harvard Law School, where he teaches administrative law, legislation and regulation, anti-corruption law, and political economy of public law. His research focuses on the application of positive political theory to public law, specifically in the areas of administrative procedure, anti-corruption, judicial institutions, and separation of powers. Prior to joining the Harvard Law School faculty, he clerked for Senior Judge Stephen Williams on the DC Circuit and for Justice Anthony Kennedy on the Supreme Court. He received his JD and PhD political science from Harvard in 2003 and his BA from Harvard College in 1997. He has served as a consultant to the World Bank and as a special rapporteur for the Commission on Legal Empowerment of the Poor. He founded and is the editor-in-chief of the Global Anti-Corruption blog, which promotes important analysis of the problems of corruption all over the world, and the blog has thousands of followers. He has written many law review articles and book chapters, and he is the co-author with John F. Manning of the casebook Legislation and Regulation, which is currently in its third edition. Professor Matthew Stephenson is definitely a world-class scholar. We are really proud and honored to have you here, Matthew. Now, Professor Eduardo Jordão is professor of law at FGV Law School in Rio, PhD in public law, Universities of Paris and Rome, and Masters of Law, London School of Economics, and University of São Paulo. Juliana Bonacorsi de Palma is professor of law at FGV Law School in São Paulo, and coordinator of the Public Group Center of Research at FGV. She's master and PhD at University of São Paulo and Master of Laws at Yale Law School. It's an honor to have you both here as well. We'll sure have a very high-level debate. And well, as I've said before, the format of this session will be quite different from the ones we have at our school. So it's important for the audience to know that there won't be a lecture or a talk. We'll go straight to the Q&A, questions and answers. Eduardo and Juliana will make the questions directly to Matthew to make it more dynamic. And I'll be here watching and learning from the three of them. As you know, the Q&A part of the session should end around 6:05, Eduardo and Juliana, so that each of you can have a couple of minutes for final thoughts or comments. And the event is supposed to finish at 6:15. Matthew, you'll have the floor for a brief initial greeting, and right after that, Eduardo and Juliana will have the floor as well for a greeting, if you like, and then you can get started with the questions, okay? Matthew, the floor is yours.
Well, I don't want to take up too much of our substantive discussion with opening remarks, but I did want to say thank you to you, Flavia, and also to Eduardo and Juliana for creating this event and for inviting me to be a part of it. I think it's very important to have these kinds of cross-border, cross-cultural exchanges about issues that are of great interest. I think the study of comparative law is hugely important and requires transnational dialogue of this sort. You're very much correct, Flavia, that while the pandemic is clearly a catastrophe for both of our countries and for the world, it has created more opportunities to have these kinds of fully online events, and I'm glad that I'm able to participate in this way. I do miss the opportunity to travel to places like Brazil. I was supposed to have the opportunity to go to FGV Rio this past April and spend a week there teaching classes and interacting with faculty and students. Something I've done before, and it was a great disappointment to me that this global catastrophe has made those kinds of in-person exchanges impossible. But I very much hope that in the future, when it's healthy and safe to do so, I'll be able to return in person and be able to interact with you all and maybe some of the people who have signed into the webinar. For now, though, I just want to say how excited I am to be able to engage in a genuine and substantive dialogue about the judicial control of public administration with two of the leading Brazilian experts in that field, in Eduardo and Juliana. And I anticipate learning as much or more from this session as I teach. So thank you very much to all of you.
Thank you, Matthew. And now, Eduardo and Juliana, the floor is yours.
If I can just start, Juliana, just to thank Flavia for the invitation to be here with you, my friends, Matthew Stephenson and Juliana Palma. It will be a pleasure to learn from you and to talk about this important topic of judicial review of administrative action. It's always a pleasure to be with you. I've been with Matthew in Rio, in Cambridge, and now online with Juliana also in Sao Paulo and Rio, and now online. Let's enjoy those benefits from the pandemics, that the opportunity to learn from Professor Stephenson here today, and maybe Juliana can start with the first question. Thank you very much.
So thank you very much. It's a pleasure to be here. An extremely pleasure, I have to say. So this may be a kickoff for something that's going to continue after the pandemic is over. So this kind of interconnection with world, with Brazil, from Rio de Janeiro, Sao Paulo, and also US and Curitiba is something to be here from now. So I'm extremely honored to be here and to start this seminar with a lot of questions. So we have very interesting questions. We were working on these questions for about 2 weeks. So we are so anxious to listen from you, Matthew, and I'm so glad to be here with you, Eduardo, my dearest friend, and also Flávia, nowadays my friend, after 1 week of talking on pandemic words. So let's start talking about this overview of the judicial review of administrative action. So Professor Matthew, one thing that is extremely important to open this debate is to know your opinion about the value of judicial review of administrative actions. So what are the goals that judicial review must pursue? And moreover, what are the set of values that judicial review of administrative actions must deal with and maybe try to have this into account. So your perceptions about judicial review of administrative action?
It's a fantastic question, obviously. It's a very broad question, and it's a question that most systems, certainly modern constitutional democracies, have to address. I think, and I hope you'll bear with me on this for a little bit, but I think to get at the question of how and why judicial review is important, at least in the American system, I want to be careful that while I think it'll be interesting for us to see whether there are similarities or differences, everything that I'm going to have to say right now will focus on my expertise in the American system, some of which may be similar, some of which might not be. But to understand the importance of judicial review in the American system of administrative law, I think it's important as a starting point to take things back a step and to think about the basic fact or problem of delegation of substantial policymaking authority to administrative agencies in the executive branch of the government. In the US system, our constitutional structure provides for a legislative branch, an executive branch headed by the president, and for a judicial branch. And the expectation seems to be that our laws will be made principally by the legislative branch of government, and those laws will be carried into effect by the executive branch of government. It turns out, though, and here I'm sure this is true of many other systems, likely including the Brazilian system, that the legislation that's passed by our Congress typically doesn't by itself specify all of the rules that people have to follow. Very often that legislation will delegate substantial policymaking authority to administrative agencies and departments that are located within the executive branch of government. And for many people, this is a source of concern or anxiety. And the concern or anxiety takes a couple of related forms. First, there's a concern about a lack of adequate democratic accountability for policy decisions. So members of our Congress, like members of the Brazilian Congress, are elected, but the bureaucrats in departments like the Environmental Protection Agency or the National Labor Relations Board or the Federal Communications Commission, for example, are not themselves directly accountable to the people. They're part of an executive branch that's headed by a president who does face electoral accountability. Indeed, as I'm sure most of the people in the audience are aware, we're right in the middle, or actually we're right near the end of our presidential election campaign. But nonetheless, there's a concern that if members of Congress, instead of, for example, legislating the specific environmental protection rules that firms have to follow, they say instead, the Environmental Protection Agency shall fashion whatever regulations are appropriate to protect human health and the environment, there's a concern about a loss of direct democratic accountability for lawmaking. The other concern is a concern about administrative arbitrariness. The idea is that the lawmaking process set out in the United States Constitution for the legislature requires, for example, passage of legislation by both chambers of Congress, presentation of that legislation to the president for signature or veto. There are many safeguards that are built into that process. The concern is that bureaucracies, administrative agencies, concentrate powers. They're not subject to the same kind of separation of powers, checks and balances, and so they might behave arbitrarily or unfairly. So those are the concerns. Those concerns lead some to say there's too much delegation in the US system and the court should step in and prohibit Congress from giving away too much of its lawmaking power. But while that view has always had some adherents, most people believe that substantial delegation of policymaking authorities to the executive branch is both inevitable and desirable under modern conditions. That the United States government has to deal with so many different kinds of problems that require so much technical expertise, for example, that it's simply not feasible for Congress to be making all the very particular decisions that one would need to make to deal with so many different areas: environmental policy, anti-discrimination law, labor policy, telecommunications law, all these things. So delegation has many advantages. We empower the bureaucrats who are expert in their field, who are able to act more quickly and more flexibly to address pressing problems, to do that, to govern. So then what happens? So we're trying to balance these competing considerations. We're trying to balance, on the one hand, our desire for flexible, effective, efficient government against our concerns about democratic accountability and administrative arbitrariness, or a lack of adequate checks and balances. And the American administrative law system tries to deal with these concerns or strike this balance through a variety of mechanisms, some of which are centrally focused on judicial review. So again, this was a long lead up, but I wanted to give that context. And again, I'm sure this is familiar to Brazilian administrative law experts as well, but at least in the United States, you need to have that context to understand judicial review and the functions that it's supposed to perform. So I would say that there are three main functions that judicial review of administrative action performs in the US system that's supposed to help address some of these concerns about the delegation of power. I'm going to say there are three, there may be more, but these are what I would say are the three main ones. The first is judicial review for adherence to the proper procedures. So one way the American system tries to address these concerns about delegation is by enacting a statutory framework that governs the procedures that agencies have to follow when they exercise the powers that have been delegated to them. And the nature of the procedures that agencies have to follow depends on the type of action that they're undertaking. So, for example, when agencies make rules, essentially regulations, there's a process called the notice and comment process they have to follow that involves letting the public know what the agency is intending to do, receiving comments, public input on that, and then responding to those comments when the agency ultimately makes its choice. When an agency adjudicates a dispute or brings an enforcement action against an individual or company, there's another set of procedures having to do with a hearing process the agency has to follow. But one vital role of judicial review in the US system is to ensure that the agencies are adhering to those procedures. And also, the courts have an important role in deciding just what those procedures are. So the Administrative Procedure Act that I just mentioned in the United States is an extremely important statute, but many of its terms are quite vague. So for instance, in the rulemaking process I just described, agencies are obligated to provide notice to the public of the terms or substance of a proposed administrative rule, make sure there's an opportunity for public comment, and to provide at the end of the rulemaking what's called a concise general statement of the final rule's basis and purpose. But there are a lot of questions about what exactly that means. And so one important function that courts perform when exercising their judicial review function is to not only enforce, but also to give content to the procedural requirements for administrative action. The second important function that judicial review performs in the US system of administrative law is reviewing for conformity with the substantive law. Now, the procedural law is also substantive law, but here what I mean is when the United States Congress delegates policymaking authority to the agency, it will authorize the agency to engage in certain kinds of actions. The statute will lay out what the agency is empowered to do. There may often be disputes about whether the agency is acting within the scope of its delegated authority under the statute, or whether the agency has attempted to do something that actually lies beyond the powers that have been delegated to it by Congress. Answering that sort of question is a question of law. And so courts will be called on to decide whether agencies have adhered to their statutory mandate, doing only what they're empowered to do by statute, also doing what they are required to do by statute. And courts will perform that kind of judicial review function as well. This issue, the issue of judicial review of agency interpretations of statutes, is the one that's governed currently by a very well-known case in the US system called Chevron versus Natural Resources Defense Council, which calls on courts to adopt a quite deferential posture to an administrative agency's interpretation of the statute that it administers. We may follow up later on in this conversation about the contours of the Chevron Doctrine. I just want to flag it because some listeners may be familiar or may have heard of that doctrine. So it's that second category of judicial review for conformity with statutory law, where Chevron is relevant. Third, under the Administrative Procedure Act, courts are empowered to strike down agency actions that are arbitrary, capricious, or an abuse of discretion. In other words, if the agency has exercised its authority in a way that is substantively unreasonable, that is, again, to use the words of the statute, arbitrary or capricious, a court may, pursuant to the Administrative Procedure Act, say that that agency action is unlawful, even if the agency has followed all of the procedures laid out in the Administrative Procedure Act or other statutes, and even if the agency's action is within the scope of its statutory authority. If the agency has acted in a way that just doesn't make any sense, that is completely contrary to the evidence before the agency, if the agency has ignored important substantive comments on its proposal, or ignored for no apparent reason alternative proposed regulations that would accomplish the same objectives without having some of the problems, then a court might say the agency has acted arbitrarily and capriciously. So these are the three main functions that judicial review is supposed to perform in the American system. And in exercising these functions, the underlying idea, to come back to where I started, is to strike the right balance between empowering agencies to govern effectively and at the same time ensuring that agencies don't govern in a way that's abusive or lawless. In striking that balance, and this is the last thing I want to say in this very long answer to your initial question, the basic tension that courts struggle with in all three of these areas is how to ensure that courts are appropriately deferential to, respectful of, agencies' substantive expertise and the policymaking authority they've been delegated by Congress, with courts importantly recognizing the limits of their own competence and recognizing that it's not appropriate for a court to second guess the expert administrators on matters of policy, while at the same time ensuring that judicial review really is meaningful and doesn't become, to use the American colloquial expression, a rubber stamp, simply upholding anything the agency does. And you see in the case law and the commentary a struggle to balance these competing considerations. You don't want the courts to overreach, but you also don't want the courts to neglect their responsibility under the statute and under a general conception of the judicial role to ensure that agencies faithfully follow the law and don't act unreasonably. And that's, I would say, the central tension that runs through both the doctrine and the scholarly commentary on judicial review of agency action, at least under American law.
Thank you, Professor. I invite my friend Eduardo to follow up with the next question, please.
Well, just to follow up to the first one then, you were talking about this important balance that should be reached by the courts. One side empowering agencies, let them do their job, but also making sure that they do not act arbitrarily when they do their job. Do you think that the balance that should be that courts in the U.S. should strike are different from the balance that should be enshrined here, for example, in Brazil or in underdeveloped countries? Do you think the fact that we have, for example, some commentators have argued that we have in Brazil such an intrusive judicial review because we had a past of a recent experience of abuses from the administration, for example, coming from the dictatorship that ran the country from the 60s to the 80s. Does that make sense to you? Would we need a different balance in Brazil than we need in the US because of our different histories of our public administrations?
It's an interesting question. There are different ways of understanding that question, or maybe different questions that are sort of nested inside what you just asked, even though it was a perfectly comprehensible and seemingly straightforward question. So let me try to approach that question at different levels. So first, there's the general question, should the system of judicial review of administrative action differ across countries based on those countries' different experiences, historical contexts, present conditions, and so forth? To that general way of framing the question, I would say, yes. I think that it would be a mistake to assume there's one approach that's the right approach for all countries or all constitutional democracies at all times. Even within a single country, even within a country like the United States, I think there's a plausible argument that the right posture with respect to something like judicial review might look very different over time. So as a general matter, I would tend to think, yes, I think countries can and should learn from one another. I'm not a believer in the idea that every country is absolutely unique and that countries can't productively learn from one another by studying their systems and getting ideas. So I definitely would endorse that. But at the same time, I don't think there's, again, I'll use an English language colloquial expression, a one-size-fits-all approach to judicial review of administrative action. Now, that's very general. So let's bring it down a level of generality. You ask whether the Brazilian system of judicial review ought to look different from the US system, and if so, in what particular ways should it be different? There, I confess I'm reluctant to give any kind of a conclusive answer, because that way of posing the question presumes a knowledge not just of the US system, but also of the Brazilian system. And I confess, even if you were to ask me just about the US system and ask whether in the US system we've struck the right balance between these competing interests that I described before, I would say, I don't know. It's hard. I can see arguments going in different directions, and maybe in this doctrine, yes, and that doctrine, no. So even if I were asked about my own system, it would be very difficult for me to say definitively that the balance has been struck in the right way or the wrong way. And how much more difficult would it be for me to try to comment on a system with which I'm not very familiar? Again, I've gotten to love Brazil. I've had the opportunity before COVID hit to visit Brazil, I think 3 or 4 times. I've not only made Brazilian friends socially, but I've gotten to know people like you, Eduardo, who I got to work with when you visited Harvard to do your studies there. I've gotten to know Brazilian scholars of administrative law, so I've gotten to know a bit more, but I don't know nearly enough to be able to say anything definitively. Now, you did say one thing that was more specific that I did want to address, which was whether Brazil's recent history of non-democratic authoritarian government might both explain and justify a greater reluctance to delegate extensive powers to the executive branch of government and a greater enthusiasm for more intrusive or aggressive or rigorous judicial review. Even there are 2 questions. There's historically, does that provide an explanation? And there's normatively, does that provide a justification? Whether it provides an empirical explanation is plausible to me. Again, I don't know the Brazilian system well enough to say, but this is a pattern that you do see in other parts of the world. Countries that have had recent experience with authoritarian systems are many times less enthusiastic about delegating substantial powers to the executive branch without a lot of constraints. So that's, again, highly plausible. I don't know if it's true. With respect to the normative question, does it make sense to me that Brazil would want to have more aggressive or more intrusive judicial review? I would say possibly, but not obviously so. One argument in favor of that view is exactly what you just laid out. In a country that has only, in comparative terms, recently made a transition to democracy, and where democracy might itself be fragile, there may be understandable and appropriate skepticism about giving the executive branch too much power. On the other hand, a fair criticism of many countries in the developing world is that they have judiciaries that are highly formalistic in their approach to law, and shall we say, unduly confident in their own abilities to decide what's appropriate behavior on the part of the administrative branch of government. And so there are arguments, and again, I can't emphasize enough, I'm not speaking specifically to Brazil, but I don't know enough, because I don't know enough. But there are arguments to the effect that sometimes you see in countries like Brazil excessively intrusive judicial review in a way that's not terribly appropriate, especially when you have this very formalistic style. And this can really impede the ability of the administrative branches of government to behave effectively. One last thing I'll say on this, which is not directly on point responsive, but I think is closely related. One needs to be careful not necessarily to equate the administrative departments of government and the bureaucracy with the executive in the form of the president. So those things can go together, but they sometimes can be disaggregated. And indeed, one of the important areas of debate in the United States in this field is whether the president needs, as a constitutional or normative matter, essentially total control over the executive branch. This is the so-called unitary executive theory, or whether it's appropriate to create various kinds of insulation for either whole agencies or departments or individual bureaucrats within the executive branch. So it is possible to have a system in which substantial policymaking powers are delegated to the bureaucracy, but the bureaucracy has its own forms of insulation from centralized presidential control. Some of those forms of insulation are themselves enforced through judicial review that might possibly alleviate some of the concerns that empowering the bureaucracy is dangerous because it concentrates too much power in the president. That may be true, but needn't always be true. It depends a lot on how the executive branch or the bureaucratic branch of government is itself organized and its relationship with the chief executive.
If you allow me to go a bit on this topic, in Brazilian administrative law, in theory, it's not very separated, the considerations that we would do as to the review of administrative agencies and to the review of the actions of the president himself. As you now have Brazilian, as I was saying, you might know that we had very polemic decisions from our Supreme Court here that deciding monocratically suspended appointments made by the president on the grounds of abuse of power. So we had, for example, former President Dilma wanted to appoint Lula as her chief of staff, and that decision was suspended by a Supreme Court justice acting alone on the grounds that she was actually appointing him only to shield him from persecution by then federal judge Sergio Moro. And recently, Bolsonaro's appointment of the chief of federal police was also suspended due to allegations that the appointment actually intended to protect members of his family that were under investigation by the police. And so I wonder, and as you know, in both cases, the appointments had to be withdrawn. How do these facts seem to an American administrative law professor? Could appointments like these be challenged before the courts in the U.S.? Have they ever been? And how would courts react to that if you can imagine that happen in the U.S.?
This is one of those areas where our systems are substantially different. In fact, in some ways, the Brazilian system looks to me somewhat more appealing than the U.S. system in certain dimensions, because in the U.S., with respect to presidential appointments of so-called principal officers of the United States government, things like heads of agencies, there is, to the best of my knowledge, very little that a court could do if it believed that the president was making such an appointment for bad reasons. Maybe there are some limited things that might be possible, but it's very, under the US constitutional system as it's been interpreted, the power to appoint officers of the United States government is vested in the president, subject only to the limitation that the president receive the advice and consent of the United States Senate, one of the chambers of our legislature. And that requirement has basically been interpreted consistently as requiring the Senate to confirm by majority vote a presidential appointment. So, of course, it might be possible if, for example, the Senate opposed a presidential appointment on the grounds that the person being appointed was guilty of various crimes or suspected of various crimes, and the appointment was intended to shield them. The Senate might withhold its consent, but there's not really, as far as I know, an analogous provision in the U.S. law that certainly wouldn't allow an individual Supreme Court justice acting alone to do anything. That's just not a feature of our system at all. But even the full Supreme Court, it's hard for me to imagine exactly how that would work. Now, of course, on the other hand, my understanding, again, with all the appropriate qualifications about not being an expert in Brazil, it's not clear to me in the US that if someone were subject to, let's say, an investigation for corruption or some other serious crime, that appointing that person to a senior executive branch position would shield them. There are special rules in the US system regarding the president. It is currently the position of the United States Department of Justice that a sitting president can't be indicted for a federal crime. This became relevant quite recently because the special counsel Robert Mueller's report on President Trump and his campaign strongly indicated, though did not conclusively state, that President Trump likely committed a number of federal crimes, most notably obstruction of justice. But the reason that Counsel Mueller's report did not explicitly say that crimes had been committed or recommend indictment was because of the current position of the US government that a sitting president can't be criminally indicted while in office. That principle does not apply to other officers of the United States government. So again, confessing my lack of understanding of the nuances of what happened to the Jill Malula situation, I don't think it would be the case that if a close ally of the president, say a former president, were under investigation for crimes committed previously, that the president could shield that person by appointing him or her to a senior office in the United States government. The criminal investigation could still, in principle, proceed to the best of my knowledge. Again, one could come up with all sorts of interesting hypothetical scenarios. What if the president wanted to take the person who was under investigation and make that person the attorney general, the head of our Department of Justice, where they might have the authority to prevent a special counsel from being appointed? Like, there's all sorts of things you could come up with. But in this regard, I feel like the US law and the Brazilian law are so different that it's hard to come up with a sufficiently tight analogy to say anything useful about what one system could learn from the other system.
Would the answer, I'm sorry, Juliana, just my last question before I pass the word to you. Would the answer be the same if we're talking about the decisions taken during the context of the coronavirus pandemics too? For example, in Brazil, we had some judges reviewing mayor decisions concerning the extent of the lockdown, the opening or closing of commerce or schools, rulings concerning the administration of polemic medicines such as the hydroxychloroquine. Did we have or could we have similar developments in the US?
It's possible. There has been some litigation in the US concerning the anti-pandemic measures, but interestingly, these instances of judicial review have not taken the form of review by federal courts of the actions of federal administrative agencies. And I think there are a couple of reasons for this. First, under the Trump administration, federal administrative agencies actually haven't done very much to deal with the pandemic. There have been some non-binding guidelines promulgated by, for example, our Center for Disease Control. And of course, there's the involvement of the Food and Drug Administration in the drug approval process, including giving emergency authorization for certain treatments. But there have been relatively few aggressive federal government actions that would provide a focal point for judicial review of federal administrative action. Most of the action has taken place at the state level, which leads into the second point that I was going to make. Most of the litigation that's taken place has focused not on the kinds of judicial review I was describing before, things about procedure or conformity with statutory law or even arbitrariness in the general sense. They've tended to focus on constitutional claims. For example, claims that applying some of these anti-lockdown measures to churches violates the guarantee of free exercise of religion in the federal constitution. And other litigation has taken place at the state level. There was an important case recently that I confess I haven't read, out of the state of Michigan, in which the Michigan State Supreme Court ruled that the Michigan state governor's anti-pandemic measures violated Michigan state law. But again, I haven't delved into the details of that case, so I don't know the specific legal basis on which that ruling was issued. But in the United States, you haven't seen as much federal administrative law decisions on these issues for the reasons that I just described. Most of the focus has taken, especially the lockdown measures, have all been enacted under state law rather than federal law. Now, if former Vice President Biden wins the election, one of the things that he pledged to do during the campaign is to use federal powers to implement federal law responses, including some kind of national mask mandate. That is a requirement that people wear masks. Now, I think his campaign has acknowledged that the federal government may not have the power to simply require as a matter of federal law that everybody wear masks. I actually think they might as a matter of constitutional law, but even putting that aside, one thing the Biden administration is likely to do is to figure out what different federal agencies can do under their existing power to adopt more aggressive anti-coronavirus measures. My prediction is that it is likely that some of those measures will push the boundaries of what those agencies can permissibly do. I would be supportive of those measures, but it's likely that they'll be stretching their mandates as far as they can to try to fight the pandemic, and that those efforts will provoke federal lawsuits by those who oppose those aggressive actions. And that might lead to the kind of judicial review of administrative action at the federal level that I was describing in my response to Juliana's first question. But we haven't seen it yet because the reaction of the U.S. administration at the federal level to the coronavirus has not been, there's this traditional concern about executive branch overreach, bureaucratic overreach. If anything, at the federal level in the United States right now, what we've seen is executive branch underreach, the failure to use even well-settled powers as aggressively as one might think is appropriate. And for that reason, we haven't seen nearly as much judicial review.
Professor Matthew, you talked a lot about the connection between administrative process and judicial review. So from the US perspective, it's something extraordinarily important, this connection between administrative process and also judicial review. So one important agenda nowadays is the discussion of what are the transformations on administrative process. So we talk about, for example, innovation, consensualism, and public governance. So these are all kind of transformation within administrative process and reasoning within agencies. So I'd like to know how judicial review reflects this transformation. What's going to be the judicial review on the 21st century?
So can I ask you to clarify a little bit more
Sure.
what exactly you mean by the transformation of administrative process? Because that could mean a bunch of different things. And what the consequences would be for judicial review in the 21st century, I think depends very much on the kind of transformation you have in mind. So can you just say a little bit more about the kinds of transformation, maybe with some specific examples of the kinds of transformation of administrative process that you have in mind?
For instance, innovation, electronic consultation, for instance, legitimation, consensualism, this particular feature of the citizen within the government. So it's not just someone that's going to receive a decision, but someone that's going to make part of the decision. I know there is something extraordinary well built on US, if you consider the comment and rulemaking process, but you have to say that now this is a little bit different because you have this kind of innovation and the electronic tools. And also I have to say that we have this asymmetry of information. So if you consider the particular maybe holds better information than the public government, especially on the field of new technologies that must require the permission of public administration. So this is a whole new agenda. And I'd like to know if this kind of new agenda, this kind of new reasoning reflects on judicial review. If there is any sort of transformation on judicial review that reflects this agenda on the administrative process.
I think I confess I'm still not quite understanding what it is that we're talking about. So let me try to unpack a few different things that you said. So one thing you referenced is there are going to be new technologies that may require approval from public authorities with respect to their use. That's certainly true. There are going to be all sorts of new technologies. I mean, we could describe some of them that are emerging, genetically modified organisms and self-driving cars and various new computer information technologies and so forth. In that sense, the technologies are new, but the basic phenomena is not new. I mean, since as long as administrative agencies have existed, they've been dealing with new technologies that aren't new anymore. So, we invent railroads, and we now need to regulate railroads, and we create administrative agencies that are specifically devoted to the regulation of railroads. We have telephones, and we need to regulate telephones and how they work. We have statutes that were written to regulate telephones, and then along comes the internet, and how do we adapt our telecommunications laws that were designed for for telephone technology to modern internet technology. So that kind of issue, again, the technologies themselves are new, but the basic structural issues or problems they represent are not terribly new. So I don't necessarily see any specific or direct implication for those new technologies for the system that we have set up. I mean, there might be, but it's not obvious what they would be. Second, there may be transformations in the administrative process itself. So maybe new technologies or new developments mean that the structures that we've put in place to try to regulate regulation, if you will, to structure the rulemaking process may start to look different. And here we have started to see some changes in this area. So in the United States, the ones that I'm most familiar with really do revolve around the rulemaking process, and they have to do with, for example, the fact that when the Administrative Procedure Act was enacted and it created this so-called notice and comment process for rulemaking, all of this would take place on physical pieces of paper. So the agency would publish its notice of proposed rulemaking in a journal called the Federal Register, which is published by the federal government, and people who were interested in federal agency action would subscribe and get physical copies of the Federal Register and read through them. And if they had comments, they would type up the comments on a typewriter and mail them to the agency. And that was the way agencies provided notice and received comments. Today, the notices of proposed rules are available online. You can go to a website called regulations.gov, and you can search and you can find all of them there. And you can submit comments online as well. Right? If I wanted to submit a comment on a rule, I wouldn't have to write something up and send it, physically mail it. I could. You're still allowed to physically mail comments to the agency, but these days, comments are going to be almost all submitted online. That also means, by the way, that it's much easier for me, if I'm interested in a regulation, to monitor what comments other people are submitting and maybe submit comments in response to what they have to say. It also may dramatically increase the volume of comments that agencies receive, right? So most rulemaking still, there are only a handful of comments because not that many people care. But for high-profile rulemakings, the agency may get thousands or tens of thousands or even millions of comments, many of which are actually sent in by bots, these robots, the same way you might get spam email. And the agency needs to figure out how to process all of this. That leads to the potential, at least, for the agencies to develop new technologies to process the comments, right? So the understanding used to be that people who worked for the agency, probably like usually low-level staffers, would actually read through all the comments and figure out which ones were relevant and how the agency could respond. Now, in a world where the agencies are receiving tens of thousands of comments, not only do agencies outsource a lot of the processing, but there's discussion of, well, can you create algorithms, artificial intelligence systems to scan these tens of thousands of comments and figure out what's important, figure out how to make rules better. So all of this is out there. And yeah, that might affect judicial review of agency action to some degree in terms of the expectations for what the notice and comment process will look like might change. Expectations, for example, for how closely commenters will be following comments submitted by others during the rulemaking process may alter. Expectations for how fully agencies are expected to answer proposals or comments raised during the rulemaking process might differ. All of these things might start to change. I'm hesitant to make strong predictions about it. At least for now, the impacts of these developments on the basic structure of US administrative law have been marginal. Not zero, not trivial, but they're kind of like around the edges, so some changes here or there. The basic structure is still the same basic structure that was put into place when the Administrative Procedure Act was enacted in 1946. There haven't been terribly radical changes. Maybe we should rethink how the basic structure works in light of these technological changes, but again, so far, without minimizing the importance of changes in technological developments, I don't think we've yet seen the kinds of fundamental developments that would cause us to need to rethink the whole system from scratch, as opposed to make, little tweaks around the edges as the administrative process changes.
If I can come back on the topic of the balance between deference and judicial review, there has been a growing interest from Brazilian scholars on American law, and more specifically in its doctrines of judicial deference. The scholars have been researching and writing a lot about Chevron Doctrine here in Brazil, for example. We would just like to discuss with you this topic, if you don't mind, because I'm sure that most of the audience that is hearing us now want to hear about this. It might be helpful to start with a general view of the Chevron Doctrine, if you wouldn't mind. And also to clarify, it's not clear to a Brazilian audience that Chevron only concerns statutory interpretation and not all kinds of administrative action. So when is Chevron applicable and when it's not? What is the idea behind Chevron? Was it a revolution, a synthesis of the law that before it? And Chevron in the future? What are the main developments after Chevron? And what can we expect from the future of Chevron? Is it under menace? This is something that we've been reading a lot, and I would like to hear you about that. I know I made 10 or 12 questions about Chevron, but if you could just give us an overview about the topic as for its past and the future, we would be very grateful.
Sure. So as you say, that's a lot of different sub-questions about Chevron. Let me do my best to try to address them. And again, I'm not sure how familiar everyone in the audience is with Chevron, so I'm worried a little bit that some of what I say might be completely obvious to many of you and maybe a little bit boring. I'm also a little bit worried that if I assume too much background knowledge, some of you who might be less familiar with this topic may feel a little bit lost. So I'll try to provide a relatively swift but also kind of comprehensive explanation of the Chevron Doctrine, where it came from, and what it's all about. So the so-called Chevron Doctrine, again, named for this 1984 case called Chevron versus Natural Resources Defense Council, has to do with the approach that courts should adopt when there's a legal challenge claiming that the agency has misinterpreted the statute that agency is charged with administering. In the specific example of Chevron itself, the statute at issue was a set of amendments to the Clean Air Act that had been enacted in 1977. And the question was, does a certain set of pollution control rules apply to each individual point source of pollution, each smokestack, or can you consider an entire facility, like a whole power plant or a whole factory, one source of pollution? So the rules said that certain technological control regulations applied to sources of pollution. And the question is, well, what's a source? Is each individual smokestack within one factory its own source? Or do we consider the entire factory a single source? And the statute didn't say, it didn't have a definition of source that answered that question. And the first administration under President Carter to interpret it said each individual smokestack is its own source. And then the Reagan administration changed its mind and said, no, actually, the whole factory counts as a single source, no matter how many individual smokestacks it contains. So that's an example of the kind of issue that might come up. What are the rules for that the EPA can impose, the Environmental Protection Agency can impose in that case? That depends on this question of statutory interpretation, what counts as a source. And the statute's not super clear on this. So what the Chevron Doctrine said is that if the court should look at the interpretation the agency adopted, if that interpretation is clearly wrong, if it clearly contravenes the intention of Congress, then of course the agency's interpretation has to be rejected because the agency is obligated to follow the instructions, the rules set down by Congress. However, the Supreme Court went on to say in the Chevron opinion, if the statute is ambiguous on the relevant point, if the court can't figure out what Congress's intent was, or if it seems like maybe Congress didn't even have a specific intent on that question, then the court should defer to the agency's interpretation of the statute as long as that interpretation is a reasonable one. And in the Chevron case itself, the court said, well, the statute doesn't clearly explain whether a source means one smokestack or a whole factory. The agency said it means a whole factory, and we can't say that's unreasonable, and so we'll uphold it. That's the basic idea behind Chevron. You asked, was Chevron a revolution or was it a synthesis of existing law? And the answer is kind of both. The court in Chevron didn't seem to understand itself at the time as saying anything dramatically new or revolutionary. The Justice Stevens, who wrote the opinion, seemed to think he was just kind of articulating or clarifying existing strands of doctrine. But as it so happened, maybe it had to do with the timing, or maybe it had to do with the particular way that Justice Stevens wrote the opinion or framed the issue, but it had a revolutionary, transformative effect in really solidifying this idea that when Congress hasn't spoken clearly, the resolution of those questions of statutory meaning are really questions for the agency, not for the court. Now, this understanding is controversial, and this anticipates what I'm going to say about another one of the questions that you asked, precisely because most people have this idea that if it's an issue of legal meaning, of statutory meaning, that's for the courts to decide, isn't it? The court's job is to decide what law means. So how does Chevron justify this idea that the court should defer to the agency's construction of the law? Well, there are some policy arguments in favor of deference. The two most important are, first, the argument that the agency has superior expertise on this issue. Right? The idea is, well, look, if Congress hasn't spoken clearly, then deciding whether a source is a smokestack or a whole factory, that's really a question of environmental policy, about how to trade off different statutory goals. It doesn't have a clear answer in the statute itself. And if that's really going to be the basis of the decision, wouldn't it be better for the expert EPA rather than the non-expert judges to be deciding that question of environmental policy? The second normative justification for Chevron deference is similar, but focuses, instead of just on expertise, on political accountability. Right? Again, the idea is if Congress hasn't spoken clearly and somebody has to resolve this ambiguous issue, it could either be the agency or the court. The court has no political accountability for its decision. The agency is not directly politically accountable. This comes back to something I said initially in my response to Juliana's first question. But the agency and the bureaucrats in the agency are part of the executive branch, which is headed by the president, who is politically accountable. So if we really are in a situation where Congress hasn't spoken clearly, and this is kind of more like a discretionary policy choice than a genuine legal choice, it would be better for the more accountable, more expert agency, rather than the less accountable, less expert court to make that call. That by itself, though, is not a completely satisfactory answer, because again, if it's a question of statutory interpretation, what does the word source mean in the Clean Air Act, then don't we still think that that's a matter for the court, because it's a question of statutory meaning? Why should we be considering expertise or political accountability if ultimately this is still a question of statutory interpretation? The key jurisprudential idea in the Chevron case that explains or justifies that kind of deference comes back to actually the issue that was the central focus of my first exchange with Juliana, this issue about delegation. So here's the idea. It would be permissible in the US system if Congress were to say, this set of pollution control regulations may apply either to individual smokestacks or to an entire factory, and we delegate to the EPA the decision how those regulations should apply. That would be allowed in the US system. Some would object to it. Some would say Congress should have to make that decision. But right now, under the under existing US constitutional doctrine, that kind of explicit delegation to the agency is allowed. What Chevron says is when Congress has left a gap or ambiguity in a statute, the court should treat that as an implicit delegation by Congress to the agency of the same kind of authority. In other words, if the court looks at the statute and it uses the word source and it doesn't say or clarify whether that means an individual smokestack or a whole factory, that is, for legal purposes, the same as, should be treated the same as a situation where Congress said explicitly, we don't have a view on this, it's up to the EPA to decide. Now, I think the court in Chevron and in subsequent cases is pretty clear that this is a legal fiction, not necessarily a strong empirical claim about what Congress actually intended. Justice Stevens' opinion in Chevron says explicitly, it could be that Congress meant to delegate to the agency. It could mean that Congress didn't even anticipate the question. It could mean that Congress actually couldn't forge a majority coalition on either side and just, kind of gave up and left ambiguous language in the statute. But for legal purposes, that doesn't matter. If Congress has not spoken sufficiently clearly, the court will assume, will adopt a presumption that Congress was implicitly delegating that choice to the agency. And if you buy that, if you accept that formulation, that answers the objection that Chevron deference is somehow inconsistent with the court's obligation to interpret the statute. The court has interpreted the statute. The court has interpreted the statute to delegate to the agency the choice among a certain range of meanings that are all consistent with the ambiguous text that Congress used. So that's the traditional legal rationale for Chevron. And again, the policy rationale for adopting that legal fiction is, as I just said, that, look, this is really more like a policy decision than a legal decision, and better to give the expert and more accountable agency the authority to make that decision. This does not mean, however, that it is uncontroversial. Courts don't need to adopt that interpretation. Courts could say, actually, no, when Congress leaves a gap or ambiguity in the statute, that gap or ambiguity is for courts to resolve in the way that courts would usually resolve statutory gaps or ambiguities. And there are definitely those who object to Chevron and think that actually it represents an abdication of judicial responsibility and an excessive transfer of power to the executive branch. Some people holding that view are now on the US Supreme Court. It does not seem they yet have a majority of the court, but the debate over Chevron is a live debate, even though Chevron itself has been on the books since 1984. And again, Chevron itself was not necessarily a complete revolution. The idea of courts deferring to agency interpretations of law predated Chevron by quite a bit. Now, the last thing I'll say, I know we're running short on time because Flávia wanted to leave us some time for some final thoughts, but you asked, does Chevron apply just to questions of statutory interpretation? The answer to that question is mostly yes, with some important qualifications. So let me explain. So first of all, some courts have applied Chevron doctrine to treaties or other international agreements as well as statutes. There's not, to the best of my knowledge, a Supreme Court case clearly on point, but courts of appeals have in some circumstances deferred to an administrative agency's interpretation of international agreements where the agency in question has the principal responsibility to enforce those international agreements in domestic law. Second, there's a doctrine that's not technically Chevron, but very closely related to Chevron, that governs agencies' interpretation of their own regulations. So sometimes an agency will have been delegated general authority under a statute. The agency will have enacted rules pursuant to that statute, but those rules themselves may contain ambiguities. There's a doctrine, it has various names. Sometimes it's called the Our Doctrine, sometimes it's called the Seminole Rock Doctrine. It has different names, but this doctrine says that courts should defer to an agency's construction of its own regulations. That's not exactly the same as Chevron. There are some arguments that deference under this doctrine ought to be stronger than under Chevron. There are other arguments, though, that the arguments in favor of Chevron don't apply here and that there shouldn't be the same degree of deference. This dispute came up most recently in a case decided by the US Supreme Court last term called Kaiser versus Wilkie, which upheld this Seminole Rock Our deference, but with some important qualifications. Given the time, I won't get into that in any detail now, except to say that's another area where Chevron itself doesn't apply, but there's a very Chevron-like doctrine that does apply. Chevron, however, does not apply to certain other areas of legal interpretation that I want to make sure I raise. First, With respect to the interpretation of the United States Constitution, no Chevron deference. Agencies don't get deference if they're interpreting constitutional provisions. Similarly, for general statutes that affect all agencies or many agencies, rather than giving authority to one agency, agencies don't get any special deference. The most important example of this that I'll emphasize is that statute I referred to earlier in my initial answer to Juliana. The Administrative Procedure Act establishes a general system of procedural requirements for all agencies to use, at least as the default rules, when they enact regulations or enforce their existing regulations. The Administrative Procedure Act contains gaps and ambiguities, but Chevron does not apply to any individual agency's interpretation of that general procedural law. Chevron only applies to statutes that agency administers. Now, there's a set of complicated questions that, again, given the time, we're not going to get into, but that are really interesting about what happens when more than one agency is involved in the implementation of a particular statutory scheme. Do they both get deference? Does neither get deference? Does one get deference unless the other disagrees? All sorts of complicated questions. But in the main, if it's an agency implementing the statute that it is entrusted to administer, it gets Chevron deference. But if it's a general statute that applies to multiple agencies, then Chevron deference doesn't apply. So that's my attempt to answer your question about the scope of Chevron's domain. The one other really important thing that I can't believe I forgot to mention until the very end that I'll bring up here is that in a very important case from almost 20 years ago, called United States versus Meade Corporation, the Supreme Court announced a very important limitation on the Chevron principle. And it actually in some ways connects to my initial exchange with Juliana again about the way that courts try to enforce constraints on agencies in different ways. Simplifying a great deal, the Meade decision indicated that Chevron only applies when the agency has announced its interpretation of the statute in a manner that is sufficiently formal procedurally. So, for example, if an agency goes through this notice and comment rulemaking process and enacts a rule, and that rule interprets a statute, then Chevron applies. But sometimes agencies declare what they think a statute means in other less formal contexts. For example, they may circulate a guidance document saying this is what we think the statute means. Or there may be a particular adjudicative proceeding. For example, in Meade, it was whether the particular goods that were being imported were in one tariff category or another tariff category, and the agency issues a letter saying it's in category X, not category Y. In those cases, Chevron may not apply. And even though the court may still be respectful of the agency's experience and expertise when deciding whether to uphold the agency's interpretation of the statute, the strong version of Chevron deference doesn't apply. And this decision and subsequent decisions have provoked a great deal of commentary and discussion, both in the case law and in the academic literature, about what kinds of interpretations are inside or outside of what we sometimes call Chevron's domain. So again, there's a lot of important and complicated material here, but let me just end on that note because I want to just stress how it highlights the idea that even though Chevron is this very important doctrine and this extremely deferential doctrine, courts have carved out exceptions to and imposed important limitations on how far Chevron extends. And that's a very important thing to understand if you want to understand how the doctrine currently operates in US law. I apologize, I went over by almost 5 minutes from where, Flávia, I know I was supposed to stop, so I will shut up now so we can all give a few final statements of wrap up.
No, it's so good to hear you, Matthew, always. But unfortunately, we are getting actually to the end of our session. I could go on listening to you guys for much longer, but it's already 6:10. So I want to thank the three of you so much for sharing your knowledge and your thoughts with us. It was a very enriching conversation. I'm really grateful to you all for making it possible. But before I finish, I'll have to comment very briefly that in November 2018, I was in Cambridge for a short course at Harvard Kennedy School, and Matthew very kindly invited Fernando, my husband, and myself to sit in on his legislation and regulations classes at Harvard Law School. And coincidentally, the classes we attended that week were about judicial control over public administration. And I must tell you that it was really special to learn from Professor Matthew Stephenson himself about the Chevron Doctrine in a classroom full of enthusiastic JD students. Matthew was brilliant as always, and it was also great to participate in the Global Anti-Corruption Lab course with his LLM students. So what I would like to say to Matthew right now is that I'll be forever grateful to you for that invitation. It was a truly remarkable experience. And I must say that I do see myself as a very fortunate person for the opportunities I've had over the past years to get to meet so many amazing and inspiring people around the globe, you guys included, of course. I met Eduardo and his wife in the very same week in Cambridge. They joined us for dinner. And Matthew and I had met 6 or 7 months prior to that at an event hosted by the United Nations in Viana, Austria. As for Juliana, even though we've never met in person, for some reason, I feel like we've known each other for years. It's been a real pleasure to have you all here. And now I should ask if you guys have any final thoughts or comments that you want, to share before we finish the session. And we can finish at, 6:20, 6:25. My concern is with Matthew, so I'm here for you guys. So now, Matthew, you have the floor again.
Oh gosh, well, I feel like I've talked enough, and I regret a little bit that I haven't had a chance to hear more from Eduardo and Juliana with some of their insights, maybe reacting to some of what I've said and maybe reflecting on the Brazilian context. I know we don't have that much time for that to happen, although maybe we can hear a little bit from each of them in their final remarks, if they have anything to say, kind of generally responding to some of the themes I've brought up. I realize I'm being a little bit selfish here. Maybe our Brazilian audience doesn't need to have this, but I would certainly benefit from hearing just how they, as Brazilian experts in administrative law, react to any of the things that I've had to say. The only other thing that I will say is again, I want to express my gratitude to you, Flávia, and also Eduardo and Juliana for putting together this event, for inviting me to be a part of it. It's certainly humbling. I mean, I'm slightly embarrassed by the kind words that you shared. I don't know if I'm any kind of international expert on anything. I still feel like I'm a student of this stuff as much as I am a teacher. But I very much, as is probably obvious, I'm a nerd, right? I love talking about this stuff. I kind of can't get enough of it. And the opportunity that modern technology affords to be able to have these conversations, not only with my own colleagues and students here in Cambridge, but with friends and colleagues and other experts all over the world, it's really wonderful. So thank you so much again for this opportunity. I hope that we'll have more opportunities to do things like this in the future, both online and once it's healthy and safe in person. And that's all I've got to say. And now I would love to hear some closing thoughts from Eduardo and Juliana. Thank you.
Matthew, we all benefited a lot from you talking about the questions that we, Juliana and I, have tried to single out that would catch the interest of Brazilian audience. What we wanted to do is precisely to bring some of the topics, some of the issues that have been were in Brazilian scholars related to judicial reviews, so as to hear a bit about your view on them. So we talked about the trade-offs that judicial review entails, about the substantial and procedural review, the judicial review of politics, decisions taken in the context of the pandemics, and of course we talked about Chevron and judicial deference to public administration. I hope with that we were able to cover in that limited amount of time that we had interesting questions that are important to the Brazilian audience and to their research. Thank you very much again, Flávia, for the invitation to share this panel with Matthew and Juliana. Thank you, Matthew, for all the insights that you gave us, and Juliana for this partnership in creating and making the questions to Matthew. Thank you very much.
So thank you very much. It's all my pleasure. What I'd like to say, reacting to the brilliant presentation, brilliant words of Professor Matthew, regarding the Brazilian system. So first, we are at crisis, and the crisis is an opportunity for reflection. So I need to go deeper on the US system and other systems to get the best for our challenges, to overcome our challenges. So I'd like to put two challenges regarding judicial review of administrative actions. So first is to get administrative process within judicial review. So nowadays, judicial review is only looking at the final decision and not the administrative process. And this is extremely bad because, for instance, if you consider the environmental issues and the problem regarding Brazilian EPA, this is just because we are not looking at administrative process. So we need to have administrative process and a strong administrative process, not only within the agencies, but especially on the judicial review. So this is the first very special lesson that must stay from Professor Matthew's speak, and that's so embedded on US culture regarding judicial review. And secondly, is to talk about legal certainty. So we need to build up a deferential doctrine that is not only because the agency has a very good reputation, or because there is, let me say, the heads are politically suited on the values of the judiciary, but because we actually have a doctrine itself, a rational doctrine, in order to make a judicial review more suitable and previsible. So this is what I would like to say regarding these challenges on Brazilian system. So first, a real administrative process. We still don't have it. For instance, rulemaking is something extraordinary weird for Brazilians to speak about notes and comment rulemaking. So it's something that's just initiating, and also legal certainty. So Brazil recently issued a law to promote legal certainty. So for Brazilians, it would be Lei de Introdução às Normas do Direito Brasileiro. And we have to struggle how to make this law fit on judicial review to have better and suitable judicial decisions. So thank you very much. It's my pleasure to have my friend Eduardo on this ship, and also to meet Flávia and the unique opportunity to talk with Professor Matthew. Thank you very much.
Thank you, Juliana. Matthew, I must ask you, do you want to comment on what Juliana said? I don't know if you have time for that.
It's not so much my own time, but I think the issues that Juliana raised are significantly weighty and complicated that I don't think I could, in just 30 seconds, give useful feedback. So I think why don't we just leave those where she put them as things for all of us to think about. And who knows, maybe if we do another one of these sessions at some point in the future, we can have a fuller discussion of those issues. Or you could invite Juliana, Eduardo, or other Brazilian experts to talk about this issue specifically in the Brazilian context. I don't think my attempt off the top of my head to engage such weighty and far-reaching issues would be able to do the topics justice right now.
Oh, perfect. I just wanted to make sure. So many thanks to the three of you. It was such a delight. And I do hope the planet overcome this pandemic soon and we can meet in person again, either in Rio or in Cambridge or in São Paulo or in Curitiba. And now I do wrap up by thanking the director of the school, Judge Clayton Maranhão, and the whole team for their support. And I thank the audience as well for joining us today. Good evening to all of you. Be safe, be healthy, be well. Boa noite a todos e todas. Muito obrigada.